Hey everyone, welcome to today's video. In this one, we're looking at a court case involving a sovereign citizen and a judge who doesn't hold back in speaking plainly. Let's get right into it.
Good afternoon. All right, we are on the record in the matter of People versus Latavius Trashad Thornton. This is case 25-0203-FY and may have appearances for the record, please.
George and on behalf of the people, Your Honor.
Thank you, and?
I'm Melissa Vachon with the Office of the Public Defender, Your Honor. I would note for the record that I am present and I did speak with Mr. Thornton. However, he is declining my representation at this arraignment.
Okay, and Mr. Thornton, could you state your name for the record, please?
I will object to being called Mr. Thornton. For the record, my name is Shoulders. I am here as legal representation for Latavius Trashad Thornton, which is a nonprofit organization.
Your Honor, I'm looking at his file from 2022. I think he was sent to competency back in 2022, and it looks like that's going to be the same issue today. It's my understanding that he might have a bench warrant out for his arrest for sentencing. He pled guilty to, I believe, attempted R&O in November 8th of 2022, but he failed to appear in December 2022. And looking earlier in the files, I believe he was sent to competency as well. And it looks like this is going to be the same issue. So if the court is inclined to send him to competency, I'd ask for that.
Objection again, Your Honor.
Everything comes through me. You're going to get your turn, okay? But I have to run this in sort of an organized fashion, in part for you, because if you want to appeal, you want a transcript that is coherent and readable, okay?
I'm sorry. I don't know. Were you speaking to me or
yes,
to
sir.
Mr. A?
Mr. Thornton. So if you want to appeal,
I just want the record to be correct, and there was no objection. There was no objection to the statement that I made about Mr. Thornton, about Latavius Trashad Thornton being a nonprofit organization, and I was just objecting the points that the attorney prosecutor made.
Okay. But there aren't objections at arraignment. There aren't objections at arraignment. And I am going to call you Mr. Thornton because that is the name that you have been identified as, and that is the name the charges are under. No, Mr. Thornton. So, the other option is to call you defendant, which is true. You are the person defending yourself, but that sounds kind of rude. So I'd rather call you Mr. Thornton.
It might sound rude, but it's true. They already tried calling him by his given name, and that didn't work.
So I want to make sure that we treat you with as much respect. Here's why we have this hearing. You have, under the Constitution, a Sixth Amendment right to know the charges against you. So we have this hearing for that reason. So I want to make sure that you get all of your rights and know everything that's available to know about this case right now so you can defend yourself. That's the whole purpose today. Give you the information you need so you can defend yourself with or without counsel as you wish, okay? We're going to do 5 things this afternoon. First, I'm going to read the charges against you, including the maximum possible penalties, because you have a right to know them. Second, we're going to talk more about your rights. Then, I'm going to enter a not guilty plea on your behalf. Give you the opportunity. Well, no, sir. So just a minute. Okay, so you're going to have the opportunity. You can stand mute or plead not guilty. We'll come to that in a minute, okay? So that's the third thing we're going to do. Then we're going to talk about dates when you return to court. You're going to get those in writing. Lastly, we're going to talk about bond or bail, okay? So,
can I please?
Because here's the thing. I don't want to be disrespectful to you.
Right, absolutely.
I know it feels disrespectful, but here's why. Here's my concern. I don't want you to say anything that could come back to haunt you later. So that's why, and this is true of every arraignment I do, I tell people right at the beginning, If you try to speak, I'm going to shut you down. And it's not to be disrespectful, and it's not because the case has already been decided. It's to protect your innocence and your interest going forward. So for that reason, I'm going to do most of the talking here.
That's fine, Your Honor. I'm
Okay,
fine with you doing most of it. But please, to protect my free speech, could you please not mute me? I have no intentions of disrespecting your courtroom. If I speak out of turn, could you just simply let me know?
Oh, the irony, telling someone they're out of line while interrupting to do it. And even though most people think you have full free speech rights in court, that's not the case. Technically, this guy is in a jail cell, but if he were in a courtroom, he still wouldn't have a First Amendment right to say whatever he wants.
And
Okay.
I am aware that I am innocent until proven guilty, and that something I say could, like you said, come back and haunt me. I'm well aware of that fully, Taylor Shard Thornton. However, I do still need to express correctly, and if I'm capable of settling this matter now, why can't we do that? I have more than just the Sixth Amendment right. I have a plethora of rights that are granted to me from God, the Human Declaration, from the Constitution, and so forth. There's a plethora of rights that have been granted onto me. So I don't just want to rely on the few far in between. I would like to rely on all my rights and abilities, and if possible, take care of all these matters in the most dignified and respectful way to keep the court's dignity and my dignity as a man. And furthermore, as a preservation of my innocence, I would like, until proven guilty, I believe that is pertinent that the innocent factor be imminent here.
Absolutely. So here's what I'm going to tell you. And I tell this to everyone at this stage. The most important thing I can tell you this afternoon is that you are innocent. You are innocent unless you remain innocent unless at some point you plead guilty or are found guilty beyond a reasonable doubt at trial. And I say unless for a reason, because it's different than until. Until means something's going to happen sooner or later, right? We'll be here until Saturday. Saturday is going to happen. Unless means we don't know what's going to happen. And in your case, we don't know what's going to happen. You haven't seen the evidence. Okay, I'm going to keep going through this and then I'll acknowledge you in just a minute. You haven't seen the evidence. No attorney has seen the evidence. The court hasn't seen the evidence. So you